Welcome. Hi, everyone, and welcome to those of you who are joining us for the second roundtable of this conference, entitled Law as the Infrastructure of Capitalism. My name is Ivana Isailović. I'm assistant professor at UVA, where I work on law, political economy, and gender. And this year, I'm the academic coordinator of the SGEL project, the Sustainable Global Economic Law Project, which is an interdisciplinary research project bringing together international public, private, and EU lawyers and scholars, exploring the intersections between global economic law and environmental and social justice. So really, it's a great pleasure to welcome our speakers, an outstanding group of scholars working on law and political economy in the global context. They've all written extensively about the relationships between law, capitalism, and inequalities from an interdisciplinary perspective. And I will just briefly introduce them. Katharina Pistor is professor of comparative law and the director of the Center on Global Legal Transformation at Columbia Law School. She wrote extensively on money and finance, corporate governance, and comparative law. She is the author of the widely acclaimed The Code of Capital, How the Law Creates Wealth and Inequality, in which she explains how law selectively codes certain assets into capital, which in turn produces private wealth and inequalities. Jason Jackson is assistant professor of political economy and urban planning in the Department of Urban Studies and Planning at MIT. His work focuses on the connections between states and markets, and his work is especially concerned with the role of technology in social transformation. And he's currently writing in two main areas: the role of anti-colonial economic nationalism and the role of anti-colonial economic nationalism in development and the rise of the digital economy. Finally, Martti Koskenniemi is emeritus professor of international law at the University of Helsinki and one of the directors of the Eric Castren Institute. He's the author of a number of books that are by now classics in international law and critical legal studies. His recent book, To the Uttermost Parts of the World, Legal Imagination and International Power, 1300-1870, traces the intellectual ideas that underlie the use of power in international context. Professor Angela Harris was also meant to take part in this conversation, but unfortunately she wasn't able to join us today. Thank you all for being here. Your contribution and your generosity are so appreciated. Now, before I give our speakers the floor for their introductory remarks, I wanted to give you a little bit of a context and hint at a few questions we hope to address in the next hour and a half. So the first panel today, earlier today, they looked at how law constructs the economy, value, and nature, and at the politics of the economic, non-economic divide, which is so prevalent in law and legal education in the global north. So the starting point for this conversation is the by now uncontroversial view that the capitalist mode of social and economic organization is inextricably linked to large-scale destruction of nature, exploitation, wealth extraction, racial and gender subordination, and the post-colonial dominance of the global north. Backed by the coercive power of the states, the law is and has been one of, or the main, depending on who you ask, infrastructures enabling, facilitating, and legitimizing environmental degradation along with social marginalization. And law plays such a foundational role in capitalism and is so enmeshed with the creation of inequalities and the destruction of nature that this raises a fundamental question about whether SGEL, Sustainable Global Economic Law, which is committed to both social and environmental justice, is even possible within capitalism. So I asked the speakers to reflect on the relationship between capitalism, law, and inequalities, and about some of the following questions. What are the legal institutions, broadly defined, that are central to understanding law's distributive effects within capitalism? What are the institutions, rules, and legal practices of a sustainable global economic law? which is both committed to environmental and social justice. And finally, what does their analysis of the above mean for legal education and more broadly for legal research? Now, about the format, speakers will have 5 minutes for introductory remarks, and then we'll have 45 minutes for a conversation between the panelists and 30 minutes for the Q&A. Please include your questions in the chat. You can also raise your hand, and I'll give you the floor towards the end of the conversation under the condition that you keep your remarks brief and to the point. And if you could also introduce yourself, that would be great. Katharina, I will let you kick this off.
Thank you so much. I hope I can be heard by everyone, and thanks for joining. I also appreciate that so many of you have their videos on. It's so much nicer to have faces on the screen than to talk into the void. So let me try to be very brief. We have 5 minutes each, and we wanted to have it succinct so we can have a debate. In the Code of Capital, I draw on a different metaphor than infrastructure. I talk about coding capital rather than infrastructure. And I think metaphors only go so far, and you can use either one. My point in talking about coding and not the codification, which is again more like infrastructure, it's this heavy thing, but it's coding, which is a malleable process of reconstituting, reproducing legal rights and interests in a particular fashion. In that book, I identify a handful of institutions that have been used over several centuries, time and again, to code different types of assets as capital: land, ideas, debt, firms, and you can go on. I think our behavior, our data is now being coded as capital by legal means, but also by digital means. So there might be a conclusion you could draw from that says, well, now we know the institutions that code capital, we just have to change these institutions and then we'll be fine. And I think that would be a wrong conclusion to draw. I think, first of all, these institutions are examples. They have been prominent, but they're not the only ones. And they're basically at a more descriptive level, but they don't tell you what's happening behind. So I'm actually in the process of writing another book, which has the preliminary title of The Laws of Capitalism, which is trying to go behind that and tries to unearth the logic of why is this possible? Why is it possible that we can see private coders of capital? Because that's one of the big points I make in the book. It's happening primarily at a relatively decentralized level. It is done mostly with the institutions of private law. And sometimes we're trying to contain them by public law regulation interventions, but it's happening in private law time and again. And so for the new book project, and I just talk to you a little bit about that because that tells you where I'm going, and I think it links to the questions that we're asking here today. The puzzle that I'm asking myself in this new project is that why is it that capitalism has been able to evade public law constraints time and again? Why is it that a system that is itself rooted and coded in law can time and again evade legal constraints? Right, and that has led me to actually the three laws of capitalism, as I call them right now. You can tell me whether this is silly, but the three laws of capitalism are: first, that we have endowed rights holder with legal entitlements that actually lack responsibility. So you can call this legal privileges in the Hoffeldian sense, or you can call them legal entitlements. Christoph Menke, the German philosopher, uses the term subjective rights, which is perhaps a little broader, but depending on how you define this, I just use legal entitlements. You have a right to do something, you're calling on this right to be able to enforce this, including against the interest of society. So once you have that, you already have a very powerful anchor to claim that you can do something with the help of institutions that you can mobilize and that you can recode and repurpose in all kinds of different ways. So that's the first law. The second law is legal arbitrage. All law is inherently incomplete and ambiguous and can be interpreted in all kinds of different ways. Plus, we have, of course, always multiple layers of law that interact with one another. And in the frictions of these different layers, you can create new law. I'm basically saying the masters of the code in the previous book. The masters of the code can code new law because they can harness the interpretive powers of the law. They use gap filling, analogy, the classic interpretation tools that lawyers have to create new types of interpretations that help them. Just as a metaphor, again, I teach with a practicing lawyer, and she tells my students always in finance, when you want to create a new asset, you look at all the existing rules and regulations as if it was the scaffolding of a building when you're trying to renovate it. And then you're trying to create something that fits through the gaps of the scaffolding, because you need the power of the law to enforce it. But you don't want to hit one of the scaffolds, because then it might be voided or will not be effective. So you have to engineer it in such a way that it fits in between. That's the core of arbitrage. It's particularly powerful when we have multiple layers of laws. And of course, in the global world, where most countries have relaxed and opened up their conflict of law rules to give private players a lot of leeway in picking and choosing the laws by which they wish to be governed. Contract law, of course, corporate law. I mean, I think the seat theory, which had required corporations to incorporate it in a jurisdiction where they have their headquarters, that's pretty much out of the door. So every corporation that is incorporated somewhere under the laws of some jurisdiction will be recognized in most other countries as fully incorporated and therefore fully capable of doing whatever it wants under that foreign law. And with the corporations, we also have basically made it possible to choose property law for financial assets, because under conflict of law rules that have been specifically created for financial assets, you can basically use the place of incorporation of the entity to claim the property rights there as well. So legal arbitrage is the second big law of capitalism. The third one is decentralized but unequal access to the means of coercion. So Max Weber and so many others have argued that the modern nation states has centralized the means of coercion. And I just want to make clear that this does not mean that access to the means of coercion is also decentralized. To the contrary, private law, basically, in private law civil procedure, coupled with choice of law rules, gives decentralized access to the means of coercion. That's basically the framework within which I think we have to think about. It's not just an infrastructure, but it's a malleable framework. I'm getting a heads up that my time is up. Let me just say one brief word about education. What do I do with my students? I mean, one is, of course, I do teach them corporate law, for example. I do teach a seminar on law and finance. In the seminar, I feel I have always a little bit more leeway, but I think what I want to tell lawyers just in general is that they have much more agency in how they structure things than they think. It might be harder in some of the law firms as young associates, but even there, I think the room to maneuver is just larger. And I'm basically trying to show them alternative ways to think about the law and to hold them also more to account that they're responsible agents and are not only in the packaging industry for their clients. Thanks.
Great, thank you, Katharina. Jason?
Great. Thanks very much, Ivana. Thanks for organizing this, and thanks for the invitation to join. So I thought I would start off by just addressing some of the broader questions that you offered to us in thinking about the distributive effects, role of law in shaping the distributive effects of global capitalism. So capitalism is, of course, synonymous with inequalities of various forms: social, economic, gendered, racial, etc., just as you laid out in your introduction. So in many ways, this is a well-established position, though, of course, one that's recently gained new impetus, for example, in the growing work on racial capitalism that argues that racial inequality is fundamental, even infrastructural, to capitalism. Legal institutions are, of course, also infrastructural to capitalism. And as such, there are also many potential questions for addressing what legal institutions are central to capitalism's distributive effects. So this is where I'll focus on my initial comments in identifying a couple areas of economic activity and economic life, and then thinking about or just identifying a couple of legal institutions that might be important for us to think about. So let me just note too, in two areas of my current work. So the first is on the digital economy, particularly in the context of urban mobility. So this is ride hailing and delivery platforms. And this is work that I'm doing through the Political Economy Lab. I'm here at MIT. And there are at least three areas of law that might be useful for us to just highlight. So tax law, labor law, and tech or IP law. So let's say a little bit about each within the context of the digital economy. And then I'll turn to the second area that I want to say something about, which is on the COVID pandemic response. So in the digital economy and tax law, so of course, tax law is part of broader international economic law, but it's crucial in allowing multinational platforms to set up different structures across different jurisdictions to minimize their tax exposure. So Uber in Amsterdam is a really good example. And so this is one of the areas where I think there is international economic law that is directly implicated in thinking about how, in the case of the digital economy, multinational firms distribute costs and benefits across different jurisdictions. Labor law, of course, is an even sharper area to sort of think about these questions of distribution, especially in the context of inequality. They matter in at least two ways we find in our work. So one is in shaping background rules that structure power relations between platforms and drivers. This point about background rules, I'll come back to later on over the course of the roundtable. But also secondly, they're being increasingly addressed by legislatures and the courts. So for example, in Europe, the recent Supreme Court decision earlier this year in Uber BV versus Aslan, and similar developments in Spain and elsewhere, as well as recent guidance from the European Commission just earlier this week. All these speak to the issue of classification. So should drivers be considered to be independent contractors or employees? And of course, this is crucial in thinking about how the distribution of risks, costs, and benefits in platform work are shared across the platform. The US is further behind on this, but again, this issue is manifesting certainly at the state level in California, in Massachusetts, in New York, and also in developing countries as well. We start to see recent discussion around this in India, in South Africa, and so forth. And so the third area within the digital economy I just want to mention is tech and IP law. So this is thinking about data, computation, algorithms, etc. And here the point about management and governance by algorithms has become really crucial, a kind of central idea in the political economy of platforms. And one crucial idea here is the extent to which algorithms are protected by IP law, and thus can retain their black box characteristics. And so when I say they're black box characteristics, I mean not just on technical sort of computer science grounds, so complexity and so forth, which is important. And that's certainly one of the ways in which algorithms serve as black boxes, but on legal grounds by claiming IP protection so that regulators can peek inside to see how algorithms work in distributing costs and benefits across players on different sides of the platform. So here specifically, we can think about pricing, for example. So how are prices determined for rides or for delivery? And also secondly, even once we understand how the price is determined, which the consumer pays, how is that revenue distributed between the platform and the driver? That's really one of the big ones. So turning very quickly to the second area of work on the pandemic response, and just very briefly, and this is collaborative work with Aziza Ahmed at UC Irvine. The two key areas that one could think about here. So first area is in thinking about the public-private divide and the way in which law works to shift risk across different people in our population. And these risks we find are unevenly distributed, especially around gender, around race, particularly when we think about work. So the extent to which essential workers are at greater risk of contracting COVID-19, have lesser protections both in the workplace and in the public sphere. Secondly, more crucially, specifically on the public-private divide, which is heavily influenced by ideas from law and economics, what we see is regulation in the public sphere, so requirements for masking, social distancing, and so forth, which have been a central part of the response really all around the world. But not in the private sphere. So it's as if, so masks in the public sphere, but no guidance on how people should protect themselves in the private sphere, so in the home, as if COVID transmission doesn't happen within the household. And so this we find reflects the public-private divide, again, deeply entrenched in law, and serves, again, to increase risks of COVID transmission. And then very finally, one other area within the broader context of the COVID pandemic response, again, speaks to IP and the global vaccine debacle. And here there are at least two issues that we can very quickly put on the table. So one, we can see how this is playing out right now with makers of the mRNA vaccines refusing to allow IP sharing for global production. In the context of first Delta and then now the Omicron variant, again, we sort of see the kind of absurdity of not having greater vaccine production and distribution around the world. I mean, as clearly as a global pandemic. And then secondly, it's worth noting that the global vaccine initiative, on one hand, there's an IP issue, but there's also a big financing issue, or rests on a sort of financial structure where countries provide resources to a central mechanism, which again relies very crucially on global economic law. So I'll stop here in identifying or sort of highlighting a few areas of law within these two broad areas of research that I'm doing, one on the digital economy and the second on the COVID-19 response, and look forward to further discussion. Thanks.
Thank you, Jason. Martti?
Well, thank you, Ivana, for inviting me to participate in this conversation from the Finnish Lapland, where it's dark, although it's day. It's a little bit like the world in more general terms, Lapland as the metaphor. Anyway, so and thanks for Katharina and Jason for really wonderful interventions. And there's so much material already on the table, so I don't know really where to start. But maybe one place from where to start would be the word capitalism, and maybe say a few words about the relations of capitalism and law. In principle, I think that the expression itself often operates like an obstacle for thinking, because we think we know what capitalism is and that the audience knows already what we are talking about, and so we can just set it on side. So I just want to say how I think about capitalism so that it seems useful from a legal perspective. And I give you two distinctions. First of all, capitalism is a system that plays with the private-public distinction. As Jason pointed out, that's somehow, in a way, if I have the time, I will elaborate in what specific way, really foundational for capitalism. And I want to say that this distinction isn't fixed like Marxists or many leftists think. I think capitalism today is much more fluid than it used to be. Neoliberalism has a lot to say about the public realm. Public and private are both operate in this system, but in a specific way. They have specific relations. The second distinction is what I call the level of struggle and the level of the background. So capitalism and law operate in such a fashion that capitalism always offers us a surface field in which professional lawyers operate. There's a toolbox, and there are institutions where lawyers operate with the toolbox in order to generate outcomes. Much of that work is, however, conditioned with background ideas, and those background ideas contain fixed positions that cannot be put to question within the institutions in which those tools work. Indeed, the tools are meaningful only by reference to a background set of assumptions. And I suggest that these two distinctions play with each other in complex ways, so that sometimes you are a public lawyer operating in a public institution, and you find that you always create certain types of outcomes, although it seems that the field might be more open-ended for other kinds of outcomes. It creates those outcomes because the public decision-making procedure is conditioned by a set of ideas about a private law background that it cannot touch, but it has to take for granted. And sometimes the other way around. Let me just give two really banal examples. So I've been involved, like many other lawyers, with the development of the investment regime. So I've spoken in various conferences and with the European Union institutions about investment treaties and investment arbitration and all that. So the level of struggle there is a level of public law. Public lawyers, I'm an international lawyer. I represent my country every now and then, and I sit in EU, or I've sat in EU institutions and other institutions. Nevertheless, the realm of decision-making is constantly conditioned by a set of ideas of investment rights or rights of investors, private rights that have been historically determined in a particular way, that are ideologically determined in particular way, ways that are embodied in private law that's outside the scope of the public law participants to mess with, or that's the assumption. So when diplomats talk to each other about possible changes in the investment regime, they always think that there's a world of investor rights that they can't struggle with. If we have time, I come back to that. Then there's an to take the reverse example would be, for instance, questions of migration, and especially migration for purposes of welfare and labor, etc. So these are questions of private rights, private labor contracts, private rights to travel and to find employment and link families, etc. Now, these questions could possibly be negotiated in different ways, for instance, with a private worker from a developing country and an employer in, say, Finland. But turns out that this is impossible because we have a whole public law realm of sovereignty and travel restrictions, a Schengen regime and a European Union set of negotiations that make it impossible. So these are just two examples on how private and public seem to relate to each other, so that one conditions what can be reached in the other. Now, my second point is my recent work has been trying to figure out the historical development of capitalism. And in that work, I have with my students, I've often put forward the thesis that that sovereignty and property are the yin and yang of capitalism. With this, I mean that these two come always together, and that we can find both temporally and geographically set different locations in which we can see sovereignty and property, the private and the public, configure each other in a specific way, so that once you have a broad historical frame in front of you, for example, as I've had in this recent book, from late medieval period to the 19th century, you will see that there are no limits through which the public realm or the realm of sovereign power and the private realm or the realm of property can be linked to each other, which I suggest is intended or can possibly be used to put to question the idea that when we today engage in questions of distribution, then we can see that what we think of as the fixed background, whilst we are having our struggle at the level of our professional institutions and competencies, the background can always be put to question, that there are always examples in history or in other locations from which you can demonstrate that the present ideas about how property relations are organized, for example, or how public jurisdiction is exercised has been made in a different way. The last thing I want to say is that the institutions that proliferate today between the public realm and the private realm set us above all strategic questions. And when I read and reread Ivana's set of questions to us, I thought that she was trying to ask us, well, how do you deal with these institutional environments? And there are two ways that you can deal with them. And that leads to my final point about teaching. So one is that you try to integrate existing institutions, for example, existing institutions of international economic law, and try to change the structural biases within those institutions by showing historically, sociologically, logically, that the background ideas about what's fixed are incorrect, and that the background is much more maneuverable than it is. Now, whether or not that succeeds depends, of course, on how powerful you can be in this institution that the structural bias of which you want to change. The other alternative is that you set up a new institution in which you have the word from the outset, and you can dictate what the background suppositions are on which the teleology of the institution then will operate in the future. And I'm really divided, and I would want to know from my co-panelists as to whether they think economic law in such a way as we imagine today is a field in which we can strategically intervene and change it so that the biases and what is believed as fixed can be changed there, or whether it's possible to imagine another field, another realm of professional activity in which we could talk with our friends and colleagues with biases about distributionary consequences, for example, which we share. My last point is that teaching students is really about teaching them either to be, teaching them to be strategically suave, so that they know when they enter the world of international or private institutions, that they know that it's a hard world out there. And even when they believe that they can change that world by entering it, what the likelier outcome is that they will change in the course of their professionalism in the institution. And when they look at the mirror, having 20 years worked for, let's say, WTO or the WHO, etc., they will see that they are just the kinds of bureaucrats that they hated 20 years earlier when they entered that world. So maybe changing something is, my last word is about sustainability. So sustainability to me signifies a truce in a struggle. So the battle is not yet won either by the environmentalists or by the economic people. And so they've decided among themselves that let's make this deal, let's call it sustainability, sustainable development, in which the development economics people get something and the environment people get something. Each will, however, hold a gun hidden behind their back. And once the moment becomes, they will shoot the other one on the forehead. And that's where I will end my diatribe.
Thank you, Martti. Thank you. So many things on the table. Katharina, do you wanna react to that private-public, your idea about giving lawyers agency, and then Martti giving us a very dark picture of please go ahead.
Yeah, I mean, I think Martti's absolutely right that the distinction between public and private is fundamental for the organization of capitalism. But I also agree that, Pashukanis and others who have written about this in the 1920s saw this as a too rigid enterprise. And I think he's right. It's fluid and can be reconstituted and reproduced. And that's what we're doing. I think, and really, I think that the investment law is one of the fundamental examples for that, how we enshrine private rights in an investment treaty between sovereigns, such that then the private rights holders think that they can hold the sovereigns at bay, using arguments that come primarily from private law. But of course, that also, you can see this in other areas of international law as well. But I think it's just a very good example. I want to just say a few words about the provocative question about can we change the system from within? Do we have to create another one? I think, I don't think we have a choice but to try to push from within. Just first of all, we don't have time, and that's sort of the climate crisis is really where, we have capitalism assumes that we have an unbounded system that expands, and everybody has, who has studied capitalism knows that, and we are facing a bounded planet. And so somehow we have to come to terms with that and have to think about how to destabilize the capitalist system to make it, to begin to internalize the cost, and individual actors have to do this, exactly what economic theories have told us. And through this incremental process, we might also find a new system. So one of the things that I wrote also in my memo is, one of the punch balls we just have to take away is the blank check to private parties that whatever they do will be backed by the coercive powers of the state. Legal certainty is the word, right? So we need more legal uncertainty, and we need so less sort of gameability, less arbitrage opportunities, because you can't calculate the outcome so easily. And at the same time, you have to mobilize others and give them tools and mechanisms to make sure that they can start holding major agents accountable for what they do. So I think I would say we have to do both, and we have to build at both, and sometimes very specific, very strategic interventions that create new types of institutions.
Great. Jason, if you want to react to anything that was said before, but I also wanted to bring you in because you mentioned when we prepared this panel, racial capitalism. So this idea of fluidity and capital reconstructing itself seems to me in tension with the notion of racial capitalism. And I was wondering if you could maybe talk a little bit about that from your perspective of a political economist working on these issues.
Yeah, sure, thanks. So I don't know that they're necessarily in tension. I mean, I would agree with Katharina and Martti on the fluidity of law, and especially I think we should try to take that as an invitation, as I think both of them are suggesting, that there's more that the existing power structures which rely on and certainly benefit and seek to more deeply ensconce current legal structures can be changed. So they don't have to be fixed, they're entry points. And the question then, I think strategically, is how to think about those entry points. So I completely agree there. On racial capitalism, so on one hand, I think one of the key insights from some of the recent work that we're seeing in racial capitalism is the idea of race as productive of some of the inequalities of capitalism. And this is a very kind of interesting sort of conceptual and analytic sort of insight and sort of potential tool to help think about some of the kinds of inequalities that we see around the world today. So, but again, race, it's so, as we all know, race is a social construct. And I think actually the ideas that we get from racial capitalism serve to further deepen that. So if we think about the original idea of sort of Cedric Robinson's original articulation of racial capitalism began not with sort of the Atlantic world and slavery and plantations and so forth, but rather began in the 13th century in Europe, to think about how different groups, what his argument was that different groups in Europe at that time were racialized as part of the early beginnings of capitalism. So this, I think, speaks to the ways in which racial categories themselves can be fluid, they can change across time. The sort of racial hierarchies that we're familiar with in today's world are not the same as those in the past. And so, well, what does this tell us? I mean, on one hand, it suggests that there's movement. On the other hand, more fundamentally, it still suggests that this process of racialization generates inequalities. And so the question, I think, is for us is to think about what role the law plays in structuring and facilitating changes in racial categorizations, and then more importantly, in generating inequalities and legitimating inequalities as well. I mean, this is another crucial dimension of law. I know this is something Katharina mentioned in her notes before, which again, I really agree with. And I think it's especially important, this role of law's legitimacy or legitimizing. I think it's especially important, unfortunately, for non-lawyers, because for non-lawyers like myself, we tend not to think of the law as malleable, and instead, I think we're even more so than I think Martti and Katharina saying about law students, even more so non-lawyers, I think, sort of take the law as law. I mean, so that doesn't mean, of course, that people don't recognize that the law can be political and so forth. But nevertheless, it's placed at a sort of higher level and seems much less, much more difficult to access, both intellectually when we think about what the role of the law is in intellectual discussions, but then also practically when it comes to thinking about the actual effects of law. So that's what I would suggest in this context, with thinking about race and capitalism as productive and generative of racial differentiation. And of ensconcing various kinds of inequalities. But the invitation then, I think, is to think about how we can restructure law to not create more inequalities, but to create more equitable outcomes.
Great, thank you. Martti, back to you. Do you want to react to something that has been said? And then I have a question for the panel before we open it up.
Yeah, so I'm interested in Katharina's point about legal uncertainty being a useful thing. So I think that's a really interesting proposal, and I'm intuitively in favor of that. But I'm also aware of the fact that uncertainty is something that liberates powerful actors in a situation where you want to bind the powerful actors. So in my critical legal world, I've learned the strategic dictum that broad standards and legal uncertainty empower certain institutions, namely the institutions that are called upon to apply that uncertain law. And you want to have uncertain law in a situation where you think that those people who are going to apply it are your friends or share your biases and structures, and you want to bind with very formal and rigorous set of rules those who are your enemies. And I have to say, when I was working in the foreign ministry, almost the only rule that it was given for us legal advisors was precisely this rule, that once you go out there in the UN and you try to develop some rules, remember that you need to bind all the adversaries, real and imagined, and liberate your own country, which made the law itself indeterminate, because you read it as binding to those people, but liberating yourself. So taking that into account, I would like to ask Katharina to elaborate her interesting suggestion on uncertainty. It has to be uncertainty in some regard, or uncertainty with respect to some institutional activities specifically. Second point is about racial capitalism. And I completely share Jason's point that race can be coded and has been coded in a number of different ways. And in my own historical work, I've seen it coded as civilization, as development, as modernity, and so on, which I think leads me to, again, to a strategic point about law's power being the power of articulation. So if you are the person who has the power authoritatively to determine the language that we speak, then you are also the person who has the power to determine the meaning of that language. And whilst teaching law students, especially questions of jurisdiction, the issue of who can say what is the authoritative language in a particular, in respect of a particular social problem or a particular dispute, for instance, that person has the power. And I wonder if fixating capitalism with the very expression and the vocabulary of race really invites us to miss a lot of places where de facto racial discrimination takes place, although the vocabulary it chooses is different.
Great, Katharina, and then Jason, if you want to.
Yes, so I take Martti's point there. It's not unambiguous to say we need less legal certainty. I was thinking primarily, again, from my perspective of coding capital, about the private law institutions, which basically, I think, give a blank check to those who are using certain types of institutions to use them, and they know that they will be enforced even if they use them in ways that are fundamentally against the interests and spirits of the law sponsors. And so I think, law itself, of course, has become kind of a commodity to create new value. IP law is an example, right? It exists only in the law. Financial assets exist only in the law. And then if the legal community stands behind these kinds of constructs and say, we will enforce them no matter what, we will enforce the IP of the big pharma, even as the world succumbs to a big pandemic, then we are in trouble. And so, we're basically not using a waiver in the WTO law, which is an international treaty, which destabilizes property rights, at least with a political condition, because it might undermine our property rights. And I think it goes back to your point of the underlying ideas, the fixed ideas, but these fixed ideas also have been institutionalized in this appeal all the time for legal certainty. You can't touch them because then the world will go under. And I think we probably have to destabilize them to just rethink what we want to give stability to, and to shift our focus on that.
Jason?
Well, just a quick word, just a second what Katharina just said, and I think again this is one of the areas where I think non-lawyers are especially, I think we're especially subject to the idea that, oh, we can't, you know, touch things like, whether it be like property rights, or buy into the idea that you know, IP law really serve the main function of IP law in its current practice. That IP law in its current practice serves is to facilitate technological innovation and so forth, despite all the evidence to the contrary around how IP in these cases is developed. I mean, again, the vaccine discussion is really amazing to think about here, because so much of the work that was done was clearly supported by governments, and everybody sees that. I mean, it's central to even the Moderna story that this is jointly developed between Moderna and the National Institutes of Health, and yet still there's this idea that, oh, you know, we have to like protect this IP in order to. It's just it's mind-boggling sometimes, but there it is. So maybe more legal uncertainty would help us to be able to, you know, as Katharina said, destabilize this sort of idea, and then put it into effect such that we get, you know, in this case, greater vaccine distribution. But of course, that's just one of innumerable examples where various forms of inequalities are underpinned by IP and other forms of property law.
Thank you. Before we open the panel to the participants, discussion to the participants, and I ask you to now start preparing your question, I raise your hand. I wanted to go back to a point about malleability and law as indeterminate. So Katharina told us, well, law is malleable. Infrastructure might not be a great metaphor to understand the law and how law operates. You also told us about how you want to give your students agency. Martti answered when we prepared this panel, well, law is indeterminate and we don't know quite what the effects will be, and turns out that we can also question some fixed rules. Jason also mentioned that he very much agreed with that, and that non-lawyers should know about how malleable law is. But I do have the feeling that increasingly these arguments are increasingly hard to make, because we've seen time and again how law creates and legitimizes large-scale expropriation and oppression. And Katharina, you brilliantly showed in your book that the development of property law has done exactly that. Commodifying land and nature has favored the interest of powerful players, from landlords to transnational multinationals. Similarly, Martti, I read your work on sovereignty and property as showing that international law can be divorced from colonization. So as we are thinking about sustainable global law might look like, it seems to me that law does pose some serious structural limitations for promoting environmental and social sustainabilities, what some authors call just sustainabilities. And I was wondering if you have some thoughts about it. It seems to me that there is this feeling that, yeah, sure, law might be malleable. We are trained as lawyers to make arguments and analyze positions so that our clients' interests will be promoted. And then we're faced with all these crises, the ecological, economic, and social crisis. So how do we think about the role of law in all of that? Is it that malleable? Who wants to start? Anyone? Katharina, should we just do Katharina, Jason, Martti?
No,
Yeah.
let Martti go first this time. I've been first so many times. Go ahead, Martti.
Well, so for the past 25 years, I've been thinking about this. I've been thinking about indeterminacy and fixedness. And I have no better response than the response that law as a logical system of relationships between rules and principles, etc., is indeterminate, and you can operate it in a zillion ways. But then law operates in social institutions and in formalized institutions, and those institutions develop structural biases. Those structural biases emerge from what people think of about life that's fixed, and that thinking about some things being fixed enables them also to fix the meaning of the laws that they apply. And in the course of institutional histories, institutions start to develop this structural bias that is then harder and harder to change in the course of times by individual lawyers when they enter those institutions. Logically speaking, it's always possible to find an to use the rule exception distinction, for instance, to logically challenge whatever. But if you go to a particular, if you are a panelist in an investment arbitration panel, for instance, you will find that, there are only very few things that you can put to question. And even if you can, in front of the classroom, you can make all of these fancy arguments. And so the two levels, the level of law as a vocabulary, as a logical system, and another one, law as a social system, as an institutional system. So that, and you have to, so law operates between these two systems. And that's why the strategic awareness is called off from students and from younger lawyers and lawyers who are looking for change. How possible do they think that when they enter these institutions with structurally biased ways of reading the law, how realistic is it for them to start to change that bias? Maybe it is, and certainly institutions differ in this regard. I've read the fragmentation of international law, that is to say, the development of ever new institutions of international law as an effort precisely by ambitious groups of professionals in particular areas. Let's say, for instance, intellectual property law or investment law or sports law. They come together and they start to say, where our biases actually represent this new type of law, which is just a law read in a specifically biased fashion. And they say, well, we are institutionally separate from, let's say, human rights lawyers. Human rights law may say this, but, investment law says that. And then you have this situation, which you now have, that there are these two groups of lawyers who read same texts in opposite ways. And there is no meta structure where you to decide this. So, and that's why what you see is a field of political struggle, as my friend David Kennedy would say, and you have to teach lawyers to be aware of that fact and to be skillful operators in that world. Skillful, at least if they are your friends. If they're your adversaries, then of course it's different.
So I agree with what Martti said. I just want to briefly add, I think, what I'm trying to tease out also with this new book project I talked about was sort of is, what is malleable and what is not. And I think, as Martti suggested, there are certain things that of course are regarded as fixed and that we also entrench and reproduce as relatively fixed. And I think one of them is sort of this rights idea, the subjective rights that you cannot take away. Another is that actually legal arbitrage is completely normal. It's just fine, right? And we see this especially in the tax arbitrage. When you look at the response to the Pandora Papers, everybody said, what's the problem? It's just legal, right? And so there are certain, but I think we couldn't have had the transposition of the legal institutions that were created for feudal land relations to IP and to financial assets if law was not malleable, right? So you can use sort of certain institutions. This is a toolbox. You use a toolbox and then you transpose them on different types of assets and into completely different contexts, while you're still asserting the same underlying ideas of these laws. And that's sort of that's the power struggle that underlies this.
Yeah, I just add to that just very quickly, just to kind of pick up on kind of the what to do. And I was thinking it's similar to Martti. If we think of sort of laws of field of struggle. So think of David Kennedy's work and also Janet Halley's work on distributional analysis, I find very helpful as a very sort of useful, tractable way of sort of mapping different actors and in thinking about very explicitly what laws matter, how they shape background power distributions, how they shape the background rules. And then oftentimes I can provide very surprising insights to thinking about, to recognizing that some actors may actually have more power in a particular conflict, or struggle than one might otherwise think. So again, it offers, I think, a useful way of connecting the idea of laws as malleable and indeterminate on one hand with what might otherwise be thought of as a more structural analysis, where you sort of like map different actors and try to think about what the relationships between them are, but then also allows you to see what kinds of resources they may have, what kinds of legal resources they may have as a result of the background rules that may be operative in the context of the particular struggle that they may be engaged in.
Yeah, thank you. I've been also thinking about this question in relation to some of my research on discrimination law and precariousness, right? So this is par excellence a law that is meant to address human rights, that is meant to address inequalities, and yet, due to the very form of discrimination law and how it was taught, it is almost impossible to get to, say, class, socioeconomic disadvantages, precariousness. And so my also questioning come from there, right? So strategy is not enough. The law is imposing certain outcomes, and you might argue based on some limited concepts that you have in order to tackle deeper form of injustices, but it is extremely, extremely limited, and you might never get there. So that's where it comes from. But thank you so much. That was very useful.